Hello. My name's Andrew Valdez. I'm with the Colorado Field Institute, and I'd like to welcome you all to tonight's presentation. Today's actually the 75th anniversary of Pearl Harbor, if you weren't aware of that. And in addition to that, I'm pleased to introduce our speaker tonight. His name's Craig Cotten, and he's the district engineer for the Colorado Division of Water Resources for an area that encompasses the San Luis Valley and the surrounding mountains. And the division has been making an effort to make water use in the valley more sustainable, and a big part of that are the groundwater rules that the state is going to be implementing in a year or two, and Craig will tell us about that.
Thanks, Andrew. I hope this goes better than 75 years ago, so we'll see. It's a pleasure to be here tonight, and I appreciate the opportunity to talk to you about the upcoming groundwater rules. I'm just going to kind of go over what they are and try to answer a few of the questions that you might have, and then we'll definitely have some time for questions after the presentation too. Okay, so the rules. We typically just say that they're the groundwater rules, but the official name for them is the rules governing the withdrawal of groundwater in Water Division Number 3, which is the Rio Grande Basin, and establishing criteria for the beginning and end of the irrigation season in Water Division Number 3 for all irrigation water rights. So kind of a mouthful there. When we do talk about the groundwater use rules, we usually just talk about that first part. But the second part of that is the irrigation season, and that's also part of the rules. And I'll talk just real briefly about the irrigation season, but most of this presentation will be on the other part of it, the groundwater use rules. So, let me see, groundwater rules. When we talk about groundwater rules, lots of questions come up. First and foremost, what are they? What are the groundwater use rules? And then the next question is, which wells will be affected? Will my wells be affected? And then once we get into it, the question is, well, why are we doing groundwater rules now? And then the question is, why didn't we do them a long time ago? So I'm going to talk about those two things first, and then we'll get into actually the use rules, what they are, how they work, which wells will be affected. Maybe? Okay. So, why now? Why are we doing groundwater use rules now? Well, we do know that wells are impacting the senior surface water rights. And for those of you that don't know much about the priority system, senior water rights are supposed to get their water first. If there's a shortage, then the junior water rights are shut off. But senior water rights are always first, kind of first in time, first in right. And then the junior water rights came after that. So in Colorado, and especially here in the San Luis Valley, the senior water rights are the ditch water rights. They were put in most often in the 1800s. And so they're very senior. The wells were put in after that. Most of the wells that we've got, the big irrigation wells anyway, were put in from the 1940s, 50s to the 1970s. And so they're significantly junior to the senior water rights. So we do have a situation here in the valley where the junior water rights, the wells, are negatively impacting the senior surface water rights, which goes against the priority system, the prior appropriation doctrine, and that's what we're trying to change here. So currently we don't have any viable way to enforce replacing depletions. The wells have to replace those depletions and stop that injury from occurring to the senior water rights. But currently, without groundwater use rules, we don't have any way to do that. So that's one of the main things, the main thing, I think, about why we're doing groundwater use rules right now. And then the other reason is that the valley's aquifers have been decreasing. The aquifer levels and the pressures have been dropping over the last, say, 15 years at least. And so that's another reason that we need to bring the aquifers into a sustainable condition, and we need to ensure that we don't drop those aquifer levels anymore. And that will actually help not only the rivers and the ditches, but also the valley's wells too. So then the question is, why didn't we do this a long time ago? We've known for approximately 40 years that groundwater use has been affecting senior surface water rights. And so what happened 40 years ago? Why didn't we do it back then? Well, in 1969, there was a legislation passed, and it was called the Water Rights Determination and Administration Act. And this was the first time in the state's history that the state engineer's office, which my office is a part of the state engineer's office, it was the first time that the state engineer actually had the ability and the authority to administer wells here in the state of Colorado. And by administer, I mean actually had the authority to go ahead and shut them off if they were injuring another ditch water right. Before that, we issued well permits, and we could shut people down if they were diverting too much water, but we couldn't shut them down because they were injuring anybody. But in 1969, that authority was given to the state engineer. So in the early 1970s, the state engineer did start developing groundwater rules throughout the state. He started on the Front Range in the South Platte and the Arkansas basins, and he developed rules in both of those basins. And then in the meantime, while he was doing that, there was, in 1972, he made a moratorium on any new large capacity wells here in most of the San Luis Valley. So we did realize in 1972 we had enough wells, and we needed to stop that, the number of wells going in here in the San Luis Valley. And so in 1972 we did stop that, put that moratorium on. And then actually in 1975, there was the first attempt at groundwater rules here in Division 3. So, and this is something that a lot of people don't realize, is that 41 years ago, we actually had an attempt at groundwater use rules here in the San Luis Valley. Now those groundwater use rules basically said that if you have a well that falls under these rules, you need to come up with a plan of augmentation or shut your wells down. Now, a plan of augmentation is a way to replace the depletions from your wells. And in a kind of a general sense, kind of a good way to describe an augmentation plan is that if a well owner has his well, it's injuring somebody, but he also has a ditch water right, he can take that ditch water right, dry up some land, take the water from that ditch, put it into a recharge pit, recharge the groundwater, and then that will offset what he's pumping. So basically it kind of just trades the water from groundwater to surface water is kind of how that augmentation plan works. And there's some different variations on augmentation plans, but that's kind of a general way that most people do augmentation plans. So in 1975, the state engineer said, okay, if you've got a well, you need to do an augmentation plan. And he gave people 6 years in which to get an augmentation plan. But he said, in the first year, you can pump 6 days a week. The second year, you can pump 5 days a week. The third year, you can pump 4 days a week. And by the end of that time period, you're going to be off unless you have an augmentation plan. Well, some people didn't like that. And there was lots of opposition to that. And in fact, there was a 12-week trial in the mid-1970s on this. And the groundwater use rules were actually wrapped up in some other things too. But that trial was a very long, lengthy trial. And then it took 2 trips to the Colorado Supreme Court. over about a 10-year time period. And by the end of it, the last trip to the Colorado Supreme Court, the Supreme Court basically said to the state engineer, why don't you look at something else? Maybe you can do something else that doesn't cause a lot of the wells in the San Luis Valley to be shut down. So the state engineer and the surface water users, who were the ones that were being injured by the wells, came up with an idea. About that time, the Closed Basin project was coming online in 1985. And they said, why don't we take the Closed Basin production and we'll put that in the river, use that to offset the well depletions. And so the surface water users on both the Rio Grande and the Canal systems thought that was a good idea. They made that agreement. And basically at that time, kind of put aside the groundwater use rules for at least a while. So in 1985, they came up with the 60-40 agreement. It was called the 60-40 agreement because 60% of the Closed Basin production goes to the Rio Grande to offset Rio Grande depletions. 40% goes to the canals to offset canals depletions. And so that agreement is still in place. We are still abiding by that. But unfortunately, the Closed Basin project has not lived up to its original billing as far as the amount of water that it can produce. Actually, not even anywhere close to the amount of water that they originally thought it was going to produce. So there is a problem right now, and we've known about that problem for quite a while now. That it's the Closed Basin project is probably not replacing all the depletions from the wells. So, So in 1998, there was some legislation passed, and in 1998 was the House Bill 98-1011. And this legislation directed the state engineer to develop confined aquifer new use rules. And this was in direct relation to some of the ideas about pumping confined aquifer water out of the San Luis Valley. A lot of you might remember AWDI. And so AWDI was just before this time, and then Stockman's Water Company was around this time. And so there were big companies that were coming in, and they wanted to drill new confined aquifer wells and pump a significant amount of confined aquifer water out of the valley. And so this legislation said, state engineer, develop rules, find out what the impact to the confined aquifer would be, and how we develop rules to offset any injury of those additional depletions. So, as a catalyst, because of that legislation, the RGDSS, or Rio Grande Decision Support System model, came about. The confined aquifer and the unconfined aquifer and the whole hydrologic system here in the San Luis Valley is very complex, as most everybody knows. And we didn't really have a good handle on how it worked. What happens if you pump a whole bunch of water out of the confined aquifer? What happens to the unconfined aquifer? What happens to the rivers around here? So RGDSS, the model was started, and this is a multi-million-dollar model that we're still improving every year, but it was started back in 1998 to try to get a good handle on the confined aquifer initially. So the confined aquifer new use rules were promulgated in 2004 after the RGDSS was up and running. They'd done a lot of studies on this, and the new use rules basically said that they kind of said no more new wells out of the confined aquifer. That's pretty much the bottom line on that one. It actually says that you have to replace 100% of the water that you take out. So why would you drill a well when you had to replace 100% of the water? So So they pretty much stopped any new use out of the confined aquifer at that time. In 2004 also, there was additional legislation, and this was Senate Bill 04222. And this is kind of the catalyst for the groundwater use rules that we're talking about right now. And it outlined principles to guide the state engineer in the development of those groundwater use rules. It said, state engineer, go forward and develop groundwater use rules. So that's kind of the start of where we're ending up right now. That was 12 years ago. So why did it take so long? Well, in 2006, we put the well measurement rules in effect. And the state engineer wanted to do these kind of stepwise. So we did the confined aquifer new use rules. And then we figured out we don't know exactly how much people are pumping from the aquifers even. So we have to get a good handle on that to see how to administer the groundwater here in the San Luis Valley. So 2006 we came out with the well measurement rules. And that says basically any large capacity well here in the San Luis Valley has to have a meter on it. You have to record the meter numbers on that every year, and you have to have it tested by a certified well tester every 4 years. And so we've been doing that since 2008, I think, was the first year that it said that you must comply with the well measurement rules. So that was in there. And then in 2008, we finally started working on the groundwater use rules. The state engineer is Dick Wolf. He was a state engineer at that time also. And he knew what a hard time the first state engineer, the original state engineer in 1975 had in trying to develop the groundwater use rules down here in 1975 and all the opposition that he got. So Dick Wolf wanted to get a lot of buy-in from the water users down here in the San Luis Valley. And so he established a 56-member advisory committee for the groundwater use rules to advise him on what people thought the use rules should look like. And so we started that advisory committee in 2008, late 2008, and began developing the rules. And only 7 years later, we've got the groundwater use rules promulgated. So they were promulgated, signed by the state engineer last fall in September of 2015. But we're not done yet. There's still some more hurdles that we have to go through. So and I'll get into that here in just a minute. So the objectives of the rules. Like I said before, we know that groundwater users are affecting surface water stream flows and ditches. So we have to take care of that. And we know that the aquifers are not in a sustainable condition. So we need to take care of that. But there was some specific language in Senate Bill 222 that directed the state engineer to do things in a specific way. So one of them, in regards to the injury to senior surface water rights, is this language. And it says the rules should permit the continued use of groundwater consistent with the prevention of material injury to senior surface water rights. Reduction shall be the minimum necessary to meet the goals. So the legislature made it very clear that they did not want the state engineer coming in and just shutting down the wells. They wanted that to be the absolute minimum necessary to ensure that the groundwater users weren't impacting the senior water rights. But then that was it. So very clear that the legislature also wanted continued use of groundwater here in the San Luis Valley. Just not to the level that it impacted anybody else. And then the other objective that was found in the legislature was to regulate the use of the confined and unconfined aquifers so as to maintain a sustainable water supply in each aquifer. So we have to get the aquifers to a sustainable level. Now that's easier said than done, and easier to figure out when you're just thinking about it than actually when you get really down into it, trying to figure out what a sustainable aquifer looks like. A lot of people have different ideas. Even the word sustainability. What exactly is that? Is the aquifer sustainable now if we just don't deplete it anymore? Maybe. But what we came up with, especially in the regards to the unconfined aquifer, is that we need to build those unconfined aquifers back to some level. Back to where they were a while ago, back to where we don't have the injury occurring to the wells and injury occurring to the senior water rights. So several things that the advisory committee really struggled with in helping the state engineer develop these rules. One of them was delayed impacts in this basin can be long-term. How do we assure that an entity is around to pay back for many years? So say that you've got an irrigation well that's near center, maybe about 10 miles away from the Rio Grande. If you pump that irrigation well this year, the impacts of that pumping might not be felt on the Rio Grande for 10 or 15 years. So, and in that time, you might have a different person that even owns the well. So the person that owned the well 10 years ago, the one that caused the depletion that's occurring right now, isn't the owner right now. So who's supposed to pay that injury? And how do we ensure that somebody is going to be around to pay that injury? Because the guy that owns it now is going to say, well, I didn't cause the injury 10 years ago. Well, so that was one of the things that we really struggled with. Another one, maximum utilization, and we talked about it a little bit before. How do we maintain the economy and ensure that water rights are fulfilled but not inappropriately curtailed? And remember, the legislation says that we are supposed to do only the minimum necessary to curtail wells. So what is the minimum necessary? And how do we determine that? And then finally, what do we want this valley to look like in the future after the groundwater use rules are finished and people are abiding by those? The San Luis Valley is unique in that our main economy is agriculture, and if we shut down the too many wells, that's definitely going to hurt the whole economy of the San Luis Valley. So the wells or the rules were have been developed with those in mind, and so the scope of the rules, what they're actually doing, they've got to remedy injurious depletions to the senior surface water rights. That's first and foremost. That's got to be done. Maximum utilization has to be in there. Sustainable aquifers, and then as far as the sustainable aquifers, what we're saying is the fluctuations in the aquifer are okay, but it's got to stay within some range. So the aquifer can go down in a low water year, kind of be used as a reservoir, basically, but then it's got to be built back up in a higher water year. No expansion of use. We've got enough wells around and enough irrigation right now. We don't want to expand that use. We can't impact the compact. The Rio Grande Compact is a compact between the states of Colorado, New Mexico, and Texas, and so we, as Coloradoans, are supposed to send a certain amount of water down to New Mexico and Texas. And well use cannot deplete the Rio Grande to an extent that it impacts the compact. And then establish an irrigation season. And so I'll talk about the irrigation season just real briefly here. Senate Bill 222 did say that we had to establish an irrigation season. And so one of the main reasons for that and how it kind of ties into the groundwater use rules, which some people think is really kind of a strange thing. But surface water rights, ditch owners had in the past complained because the irrigation season right now is typically April 1st to November 1st. After November 1st, you get the rivers and streams start freezing up, your ditches start freezing up. There's lots of problems. You can't even get the water out of your ditch a lot of times after that point. But a person with a well could find a warm day in January, say, and go out there and push the button. Surface water users did not like that at all, and they complained to the legislature, and they said, we need an irrigation season that is the same for everybody, surface water rights and well water rights. And so that was kind of the impetus for putting in the irrigation season here in the rules. So now that we've got the rules, what types of wells do they apply to? Well, the main one, and I think everybody understands this, is irrigation wells. The vast majority of the wells that are going to be part of the groundwater use rules are irrigation wells. But that's definitely not the only type of well that is going to be affected by these rules. So we do have municipal wells also. Every municipality in the San Luis Valley that relies on wells, their wells will be subject to these groundwater use rules. And so they're actively working to develop plans to get into compliance with these groundwater use rules. I think every municipality in the San Luis Valley has talked to us on multiple occasions about what they can do, what they should do to kind of come into compliance with these rules. Larger commercial and industrial wells. We don't have a whole lot of these industrial wells, but we do have a fair amount of commercial wells. And commercial wells that would fall under these rules can even be down to the size of like a potato storage warehouse well, humidification type wells. Those, in most cases, will be subject to these rules, and so they have to come into compliance with that. And then most central water system subdivision wells. If you've got a subdivision out there that has a central water system and you've got just one or two large capacity wells that run that central water system, those will most likely be falling under these rules also. And then finally, wildlife wells. The Fish and Wildlife Service has been very proactive in trying to figure out what they're going to do with all of their wildlife wells. So they've got wildlife wells on the Baca, on the Monte Vista, and on the Alamosa wildlife refuges. Those are all going to fall under these rules. And so they've been, like I say, very proactive, trying to develop plans to work within the rules, still allow their wildlife refuges the water that they need, but also comply with the new state rules. So rules do not apply to these types of wells, and this is the category that you want your wells in. House wells. Almost all house wells will not be affected by these rules. There are some limited exceptions, like subdivision wells if you have a central water supply, a couple of other exceptions, but by and large, most house wells, most domestic wells will not be affected by these rules. Livestock wells. Similarly, if you've got a small livestock well out there just used for livestock purposes and it's decreed or permitted for livestock purposes, it won't be affected by these rules. Small commercial wells. These are what we call exempt type commercial wells. This is, for instance, if you have a gas station and you need a well to have a bathroom in the gas station. Very, very small amount of water. They won't be affected. Something that a lot of people don't realize the closed basin project wells will not fall under these rules. And that's because they were initially put in to offset well depletions. That's that's still is their whole purpose, is to offset well depletions. And so they're offsetting their own depletions plus other wells' depletions. And then fire wells. If you've got a well that's capped and locked and only available for firefighting purposes, it will not be subject to the rules. So, kind of what are the rules and what do they not do? They don't relieve wells of the obligation to replace their injurious stream depletions, and this seems kind of pretty straightforward. But we just want to make sure that people don't think that once we have rules, they can do anything that they want. They still have to replace or remedy their injurious stream depletions. They do not allow an expanded use of water. So if you've got a well out there, an irrigation well, and you're complying with the groundwater use rules, that doesn't mean that you can irrigate more land. You're still limited to what you can do. They don't relieve wells of the obligation to comply with their permits, rules, or decrees. Almost all wells here in the San Luis Valley either have a permit through the state engineer's office or a decree through the water court, or in most cases they have both. And they have limitations on those permits and decrees about how many gallons per minute they can pump. For irrigation wells, what land they can be used on, those sorts of things. And so people still have to abide by those regulations in their rules and in their permits, rules, and decrees. So you've got a well that's going to be subject to the rules. What can you do? There's basically three options for well owners. The first one, and the one that I think 95% or more of the well owners here in the San Luis Valley will take, is to participate in a groundwater management subdistrict. We're probably going to have 7 total groundwater management subdistricts within the San Luis Valley when it's all said and done. 6 of those will be subdistricts of the Rio Grande Water Conservation District, and 1 will be a subdistrict of the Trinchera Water Conservancy District in Trinchera, in the Trinchera Creek area. So those are areas kind of like a fire protection district or an ambulance district. They're an area where you pay a tax or a fee to be in that sub-district, and then they give you some benefit of that. Now, the benefit of the sub-district is that they take the amount of the money that they collect from well owners in that area, and they do things like buy surface water ditches to leave water in the stream to offset the depletions. Or they might pay people to fallow their lands so that there's not so much pumping and so that we can build the aquifer back up. So that's kind of in a general sense what the sub-districts are going to be doing. We've got one sub-district right now that's been in operation for about 4 years, and that's sub-district number 1. That actually handles a large number of wells kind of in the central part of the San Luis Valley, mostly irrigation wells. And so it's, like I said, up and running. People pay into that sub-district every year on their taxes from the county. That money is used to purchase water, to pay people that may be otherwise injured by well pumping, to fallow land. I think there's about 9,000 acres or something of dry up right now in that area, fallowed land. So that's what they're doing, and then there's other sub-districts that are coming online in various stages that are going to be coming online here in the near future. So, like I say, that 95% or more of the wells probably here in the valley are going to be in sub-districts, but you don't have to be in a sub-district. The other option is to obtain a plan for augmentation. Some people are looking at this, especially if they've got wells and surface water rights, and they can actually take some of that surface water right and recharge it to offset their pumping. They're looking at doing something like that. That's got to go through water court, and it's maybe a little bit lengthier process just for an individual, because you have to do that on your own. Sub-district is, you have the Rio Grande Water Conservation District and their lawyer helping you out with that whole thing. You don't have to do anything except pay them. Plan of augmentation, it's your deal, but there are going to be some people that do that. Third option is shut your well down. This actually is probably going to be the option that some people choose. I would say that the vast majority of well owners will choose number 1 or 2, but there are some well owners that are going to say it's just not worth it. I can't pay the fees of the sub-district, or I can't do the plan of augmentation. I'm just going to shut my well down. So the rules, as I said, filed in water court last September. So what does that mean? The rules were signed by the state engineer, finished, but he's got to submit those to water court. They've got to go through the water court process, and that means that people have the ability to object to those rules if they think that there's something wrong with them. So in this case, we actually had 30 statements of objection to the rules. These were either individuals or groups of people that had problems with some part of the rules and regulations. Now about 10 of those were what we call objections in support of the rules. They were people or groups that, for the most part, thought that the rules were pretty good. They just wanted to be involved in the case, just in case something came up and that they wanted to have a say in. And so they told the judge, yeah, we're gonna fill out a statement of objection. We really don't have anything that we're concerned about, but we want to be in the case. So we have roughly 20 people or entities that have some definite objection to the rules. In looking at those, I don't think that there's anybody that's done a statement of objection that says that they don't like the rules at all, that they don't think the rules are valid at all or should be done at all. They're mainly people that just have parts of the rules that they don't like, and so some of the reasons for those objections, some of the general ones. One is a sustainability concern. As I said earlier, we've had to come up with kind of some of the guidelines for sustainability, and that's kind of, everybody's got their own idea of what sustainability is and how we get there. Some people are concerned that what we put in the rules may not be quite right, and they want us to reevaluate the sustainability portion of it. The other part of the sustainability kind of falls under that is proportional responsibility. Say you're in an area with 199 other wells. You've got one well. People around you have 199 wells. The aquifer's dropped 20 feet. You need to bring it back 20 feet. What is your one out of that 200 number of wells? What is your responsibility to bring that aquifer back? And how do you figure that out? Different wells in different areas, different pumping amounts. How exactly does that work? And so we've got some things in the rules that we think will work for determining that responsibility, but there's been an objection on that. People think that maybe that's not quite the way we should do it. One of the reasons for objections of some people are that the compliance dates are too strict. These are usually well owners that say the compliance dates to meet the obligations of the rules are coming up too fast. There's not enough time to get sub-districts in place, not enough time to get our augmentation plan in place. We just need more time. On the other hand, we've got some objections that say compliant states are too lenient. These are usually surface water users that are saying, hey, I've been injured for the last 40 years. I want the well shut off right now. And you're giving them a year or two to get their plans in place. That's too long. And still others are objecting to the irrigation season. So that's another a big part of the objections there. So when will the rules be effective? They're in court right now. They've been signed by the state engineer. We had the legislation back in 2004 that said for us to develop these rules. What's the deal? Well, the judge, the water judge, is Judge Patty Swift, the district judge here, and she scheduled an 8-week trial a little over a year from now in January and February of 2018 for all of the objectors. We are actively working with the objectors, trying to come up with some stipulated agreements so that we don't have to go to that trial. But if we need to, there is an 8-week trial scheduled, and I'm fairly certain that we're probably not going to reach stipulated agreements with all of the 30 objectors. There'll probably be some that we can't reach a stipulated agreement with, and we'll end up going to trial, and then the judge will make a decision. So that trial is scheduled for a little more than a year out, and then the rules will become effective on the date when all protests have been resolved. So that means basically if Judge Swift makes a ruling on that and said, okay, I'm going to get rid of all the protests, for instance, I'm going to say that the rules are good. If nobody appeals that decision, that's the date that those rules will become effective. If somebody appeals that decision, it goes to the Colorado Supreme Court, and then we go through that process, and then on the date that they make their decision, that's the date that the rules will become effective. So we're probably talking, if it's not appealed, I would assume that the judge would make her ruling mid-2018, thereabouts. And assuming that she upholds the rules, then they'll go into effect then. If it is appealed, it'll probably add at least another year onto that. So, after they are effective, what are the deadlines for people to meet the obligations of the rules? Well, if you're going to be in a subdistrict, within 1 year of the effective date, you have to have your subdistrict formed. And we've actually got several subdistricts that are already formed, and so they're ahead of schedule on this. If you're going to do your own augmentation plan, you have 2 years within the effective date of the rules to come up with your augmentation plan. But you have to be operating under what's called an SWSP, or a substitute water supply plan, which is kind of a temporary plan, temporary augmentation plan that you need to be operating under.
Can I ask
Sure.
is this 2 years after Patty's decision?
Yes. Mm-hmm. Yep. 2 years after the effective date. So, yeah. And then, as always, if you can't meet those deadlines, you have to shut off your wells. So, what are the effect of the rules? It's been kind of an interesting thing. Irrigation land prices have really shot up since we started talking about the rules, which is just completely opposite of what most people thought would happen. But I think one of the reasons is that people actually see some promise of some stability here in the San Luis Valley. They know that we are working, that we will have a sustainable aquifer in the future. We will have a situation where if you have a surface water right, you're not going to be injured by groundwater pumping. And so, like I say, land prices, especially land prices with wells and surface water, have just skyrocketed, in my opinion, especially over the last 5 years. And so that's probably a good thing about the rules, is that they're actually maybe causing some land prices to increase. As I said before, we are probably going to have some well owners who will just have to discontinue their well. In large part, these are going to be people that maybe have surface water that they can fall back on, and the well is just a supplemental supply, so it's not as big of a part of their operation, and so they can get rid of their well and still make a living. But we will have that situation happen, I'm sure. So now in Subdistrict 1, for instance, people are paying $75 per acre foot pumped. On average, you can say that there's about 2 acre feet per acre pumped, so you're paying roughly maybe $150 per acre foot or per acre of your ground in additional fees, and then you got administration fees and some other things. But so somewhere around that $150 per acre that you have, and so that's a significant chunk of money. But for the majority of well owners, especially sprinkler irrigated owners, it's a manageable cost, I think. So I think that they can still make a good living and abide by the rules and still keep their wells going. So with that, that's my presentation. So I'll definitely take any questions that anybody has. Yes, ma'am.
Is this available to us on the web?
I don't know what they're going to do.
It's being filmed, and it'll be available on the Adams State YouTube channel. So we can send out an email afterwards with a link to that.
Yes, ma'am.
I've got a couple of questions.
Mhm.
With the augmentation plan, whatever is pulled out of the well, does that have to be returned 100%, or will it be a percentage back to surface?
Generally, with an augmentation plan, the consumptive use portion has to be replaced 100%. So it's not the total pumping amount, but it's the part that's consumed.
Consumptive use, explain that to me.
So say you've got a well that you use to flood irrigate. You flood irrigate your field. Generally on flood irrigation, it's about 50% is taken up by the plants, and about 50% seeps into the ground and goes back into the groundwater. So a well owner in that case only consumes about 50%. Now, if you have a sprinkler, you're consuming probably around 80 to 85% because it's a lot more efficient. You still probably consume the same amount, because the plants take up that amount, but just you put less on the plants, and so less is getting back into the groundwater. Yes, ma'am.
Another question. Actually, I have a couple more. That's okay. All right. If you belong to a subdistrict, because I think Alamosa is going to be Subdistrict 6, I believe. That will be a new.
Yes.
Okay. In a drought year, can the subdistrict restrict the amount of water to each shareholder? So if we're generally allocated a certain amount of money to the state, and we're hitting a drought year, there's only so much water allocated or allowed, we are only going to be given a smaller amount of water.
Each of the subdistricts can come up with their own plans and how they're going to operate it. I do not know what Subdistrict 6 is going to do with their plan.
I don't think they know yet.
Yeah. Amber Pacheco would be the one to answer that one.
So some of the subdistricts have included in their conceptual plans of water management language that says they could restrict on a percentage basis well use in a subdistrict, but without a board to lay out the details of that, we can say they would or what that would look like. programs may be based, programs in the sub-district where you pay your neighbor and say, well, you restrict 5% and I'll only restrict 2%. I'll view from your credit. It could go a lot of different ways, but it is a possibility.
Yeah, because that's something with a municipality to just tell everybody, whoa, there's only so much water and you can't use it, so that's.
And most people that are living in towns here in the San Luis Valley have probably seen their water rates go up over the last 5 years or so. And one of the main reasons is because the municipalities are getting geared up to spend some money so that they can abide by these rules.
I've got one more question.
Sure.
Shoot, my foot. With the Rio Grande Compact, I've always been curious, how much does Colorado keep and how much does it have to return down to New Mexico and Texas?
So the compact is on a yearly basis, and so there's not we don't need to deliver any water on a specific day. So it's just an annual amount, but and it actually changes. If we have a low water year, we get to keep more of it. If we have a high water year, we have to let more of it down. But on an average year, on the Rio Grande, it's probably about 25% of the water that we have to pass down.
So we get 75.
Mm-hmm.
So that's why
Yeah.
New Mexico pays us all.
Yep. Mm-hmm. Yeah. And on the Caneos, there's actually two parts to the Rio Grande Compact: the Rio Grande main stem and then the Caneos system. And on the Caneos system, we have to deliver a little bit more, about 30% down there. Andrew?
How many metered wells are in the valley? What's your annual production?
There's about 6,000 wells that, if they were in operation, they should be metered. Now, people do have an option to just inactivate their wells. If they're not going to use them, they can say, I'm going to discontinue it from power, for instance, and I'm not going to put a meter on it. But if all of them were active, there'd be about 6,000. So there's about 4,500 that actually have meters on them now.
And their total production?
I think around 500,000 acre feet would be my guess.
Does the plan address recharge to the confined aquifer and how that can be done?
The plan doesn't directly address that, how that can be done, but it does say that the confined aquifers have to be raised back, and this is part of Senate Bill 222. They have to be raised back to the levels that they were in 1978 to 2000, to that time period. Now, well owners, either through a sub-district or their plan of augmentation, have the ability to figure out different ways to get that, to meet that sustainability level. Some people are looking at recharge pits along the rim so that they can get some more water to the confined aquifer. Other people are just looking at shutting confined aquifer wells down so that there's not so much draw on it. Yes, sir.
What proportion of the wells, of the 4,500 active wells, are down as far as the confined aquifer?
I don't know exactly, but I think we've got more unconfined aquifer wells than we do confined. But it's not a big difference, I don't think. So maybe like 40% are confined, would be my guess.
Could you talk
Yes,
just a little bit about confined versus unconfined water?
Sure. So we have generally two aquifers here in the San Luis Valley. The unconfined is our top aquifer, and it's generally from like 6 to 10 feet down. You can, most places here in the valley, you can hit water down to about 100 feet on average is the unconfined aquifer. Some places deeper, some places shallower. And then we've got a clay layer. It's called the blue clay layer, although it's not always blue, but in most circumstances, it's kind of a bluish color. And it separates the two aquifers. Now, below that blue clay layer, the blue clay layer kind of acts as a top to that confined aquifer, and it pushes down on that confined aquifer, and you've got the confined aquifer goes from that point down and can be several thousand feet down in depth, and it's under pressure because of just the shape of how it is. And so most places, when you punch a hole into the confined aquifer, you get artesian pressure and artesian flows. So not always in all parts of the confined aquifer, you can go into the confined and not get artesian pressures, but in a lot of places you do.
So in terms of relative size, the confined is much larger volume of water.
Yeah. Mm-hmm. Yeah. Mm-hmm. And it's a lot more difficult to try to figure out, just because it's deeper and goes to a large depth in some places, and we just don't have we didn't have a really good handle on it. We're getting a lot better at that now. Leroy?
Are you going to treat a confined well and a non-confined the same throughout the valley? Are they all going to be treated in that manner?
They're going to be treated the same as far as what they need to do, as far as replacing depletions to the streams and having a sustainability component. But they will be treated differently just because they're going to be in different response areas. And so this is, for everybody else, I think some people understand response areas, but if you don't, response areas are areas that the model has come up with that the wells in that area are kind of similarly located in a similar confined or unconfined aquifer situation. And so we've come up with areas that the wells are we believe are kind of can be treated equally in that area. So wells within each response area will be treated the same, but a well in one response area might not act exactly the same as a well in another area, if that makes sense. So
That doesn't make a lot of sense as far as the response areas are concerned, because there's no response areas on the north side of the river.
yeah, there are the Subdistrict 1 has its own response area, and then Saguache and San Luis Creeks have their own response area.
Because, they've got they've got a lot of wells in that area that are coming out of the confined, not just the unconfined.
Mm-hmm.
And so,
Yeah.
I just haven't seen, there's a lot of difference from what I understand what's going on.
Yeah. So.
Try to get it better.
Yeah, so the wells in each response area, they'll have a sustainability component like I talked about. So they'll have to sustain the aquifer. But the way that we're doing that with the model is that they'll only have one aquifer that they'll primarily be responsible to sustain. So for instance, Subdistrict number 1, most of the wells are in the unconfined, and so they'll have to sustain the unconfined aquifer. Even though they have some confined wells there, their goal is only directly related to the unconfined aquifer. And it's our belief that if we sustain the unconfined aquifer, that'll help the confined also. And we've got some areas that are vice versa, mostly confined wells, but some unconfined.
Greg, as I understand it, the attempt is to stabilize the aquifer, and to stabilize it by talking people into shutting down their wells, drying up the land. What happens when the aquifer is not coming back? And is there enough money there to continue to get people to shut down, or what happens when there's not enough money, people want to keep pumping?
Yeah, so the rules are designed such that it's not the state coming in and telling people exactly what they have to do. We're just telling them what the goals are. The goals are to sustain the aquifer. However they can get that done is great, but they have to get it done. So if they set their limits on their amount of money that they're collecting through the sub-district and it's not enough, they're gonna have to change that and collect more money, so.
Well, when you talk about more money, you're talking about money that we're paying into the sub-district, and the sub-district takes that money and pays him not to pump this
Mhm.
year. is
Yeah,
what the
for
money's
instance, yep. Mhm.
But it could eventually come down to the sub-district says, if it's set up this way, okay, we're gonna have to start shutting down wells. We're gonna pay you $5,000, you're not gonna farm this year. That's the deal.
That's a potential solution, and I think, and here again, Amber can correct me if I'm wrong, but I think some sub-districts have at least looked into the idea of each well, if you're gonna be in the sub-district, you have to upfront cut back
Right.
10% or 20 or something like that, just right up front.
Yeah.
So yeah, sub-districts have a lot of leeway in how they want to address the problem.
And with 6 septic, there could be 6 or 7 different ways.
Yeah.
Just depends on which sub-district you happen to be in.
Yep, and I think that's going to be the case. Yeah. Kevin?
I don't know if this even exists, this problem, but what number or what percentage of wells currently are maybe flowing up more than what they're permitted or decreed to be doing?
We hope none. But
As reality goes.
yeah, realistically, we are finding some out there. We're addressing those when we find them, and really the meters on the wells are helping that immensely. We can go right out there and tell exactly how much those wells are pumping, and we know if they're meeting their requirements or not. So.
So my next question then would be, with regards to the rules and regs, then, if they're being afforded full right to their permitted or decreed amounts, then basically the only attack right now is just strictly by charge per acre foot pump. Is that the limiting factor then? Or is there any part of the rules that would say, for a given year, you can only pump, say, 80% or 90% of your decreed amount in a given year?
So the rules don't say anything about that. There again, because we want this to be a water user-led solution. All we're saying is you have to abide by your permits and decrees. You can't pump more than what your decree says. But if you want to buy an iceberg in Alaska and truck it over here and recharge the aquifer, that's something that you can do. You know, as long as it meets the requirements, gets the aquifer up and doesn't hurt the senior water users. Whatever works and whatever people want to do in that area, they can do that. Cleve?
I was just gonna tag on a little bit about, interestingly enough, when farmers haven't had to pay an assessment on their water, on their groundwater withdrawals, and then you start having to pay $75 an acre foot, some things happen. Conservation comes into play right away. The answer to this problem isn't complete shutdown of wells or irrigated ag in the valley. You'll automatically see conservation efforts. Secondly, I've always advocated there'll be something displace some of the higher consumptive use crops that we grow here. We raise about 150,000 acres of alfalfa. Well, I'm one of them. And it's highly consumptive use crop. Something, I can't tell you what it is, whether it's hemp or it's quinoa or malt barley or something else. Economics will drive farmers to raise something else.
Yeah.
And then lastly, there will be probably some amount of less irrigated agriculture in the valley. And hopefully it's those individuals. Sub-District 1 set their plan up to create a cushion or a soft landing for those that didn't want to farm for right now. So they can sign up in a 15-year program to idle there their property, put it in a, conservation effort to sustain the soil, native grasses, and let it sit idle for 15 years and be compensated for it. So those are the things, I just wanted to highlight it, it's not a doom and gloom, we're gonna dry up 100,000 acres of productive ground in the valley to solve the problem. Unless
Right.
Mother Nature completely turns around and goes the other way, I mean, that
Yeah.
could be a reality whether you had groundwater rules and regs or not. If Mother Nature takes a really bad turn on this, it'll be devastating.
Yeah, good point. There's lots of options, and people are definitely cutting back just because they have to pay some for the water.
For Subdistrict 1 has, cut as early as 2011, their total pumping in Subdistrict 1 was over 300,000 acres for the year. And now they're down to they've cut a third of their pumping out. And they've taken some productive ground out. Through the CREP programs, it's probably about 5,000 acres. There's been some other one-year following programs. There's some insurance preventative planting programs that have pushed that up annually to 7,000 or 8,000 or 9,000. But they've mostly done this through better conservation efforts and awareness and different cropping patterns, some green manure products instead of just maybe intensive year after year after year after year farming. So, I mean, the tools are there and farmers are very adaptive when they have to be.
This is kind of an unfair question, but politics and money always create some kind of weird marriage. My question is, and it kind of follows on to the last few comments, is what level of confidence do you folks have that this is going to solve the problem? Or will there be future shoes dropping?
There's always something that's going to come up, always some problem with water. But I really think that as far as the two main things that these rules are designed to alleviate, sustainability of the aquifer and replacing injurious depletions to the rivers, I think those will get done. Yeah. And then we'll get this done, and then there'll be something else that we have to tackle.
I can't remember, do any of you guys know how many wells the city of Alamos has?
Well,
That it uses or it has?
well, I would assume that in the summer they use all 12 of them.
Really have 12 wells? That's a lot of money.
That sounds about right, confined and unconfined. The city uses for drinking water facilities, mostly the confined wells, but they do have some unconfined wells also, so.
In a previous presentation where I attended and they talked about the science of the confined aquifer, if I'm not mistaken, the number that they threw out was that the aquifer here is at about 93 to 95% of original volume versus some of the aquifers, say in California, which have been depleted, like the Ogallala aquifer has been depleted tremendously.
Yeah.
The question I have is, based on your big data that you've been collecting from the confined and unconfined aquifers, do you have a timeline in mind based on historical snowpack and rainfall, when the aquifer will be repleted?
So each aquifer is going to, and each area is going to be a little bit different. But for instance, Subdistrict number 1, which is already up and going, they have a period of 20 years to replace the aquifer, or to get it to that sustainable level. They've already gone 4 years of that, so they've got 16 more years to build that up. And they're the last 2 or 3 years, they're making good progress on that. So.
as well, you know, historically, ag land has been removed from production through urbanization and
Yeah.
so on and so forth. That I can't feature that really happening at a really huge level here in the valley. But is that part of the data?
It's definitely a concern that we have, and you're right that we don't have big municipalities that need a whole lot of water here in the valley, but we do have big municipalities outside of the valley that are looking for water.
Right.
Yeah.
I'm familiar with that.
Yeah.
Comparatively, urban use or municipal use compared to ag use, percentages.
As far as the amount of water
Yeah, I mean,
that
and
they,
you take a shower, it goes in, you know,
oh,
in my case, it goes back.
Yeah.
It's treated and goes back into, so is
Yeah.
that like a net zero kind of a situation?
well, general rule of thumb is municipal uses, if you're just talking about, especially just in-house uses, are maybe 10% at the most consumptive use, 5 to 10%.
So 90% of goes back.
Yeah,
Some-
yeah, right. And whereas agriculture, if you're talking about a sprinkler system, only about 17% of that goes back to the ground. Mhm. So, and that's a kind of an interesting thing too. We talk about efficiency on wells and systems, and you can get more efficient on systems like going from flood irrigation to sprinkler, but it's not always a good thing when you're talking about the amount of water that you're using. You are getting more efficient, but that means that you're using up more of the water that you're pumping out. So,
If you just look at the amount of water in the drain ditches that it used to be when everybody's flood irrigating,
yeah, right.
compared to what the drain ditches, when wildlife and all that, you know, that used to be underwater
Mhm.
now,
Yeah,
because
and
there's
that's
no runoff from the sprinkler.
exactly right. That's exactly why we don't have water in drain ditches, or one of the main reasons. Yeah. The other one is that our aquifer levels are down and it's going into the ground. But yeah, that's right.
I had kind of a quick comment.
Yeah.
Craig could probably spend a whole nother hour or two talking just about compact and the history of the compact. And somebody reminded me one time, so this generation's kind of got its burden to bear with the rules and regulations, but years ago, there was a whole generation that had to deal with the state intervening in compact administration and said, we'll never survive this, our economy will fall apart, and we found a way in the 60s to adhere to the compact and survive.
Yeah.
This generation now has a whole different set of standards and crosses to bear, but we'll figure it out. It's been ironic to have lawyers from California come in my office representing interests that are, to Craig's point, the value of land here is increasing. So lawyers from California come by to ask, okay, how do we stay compliant with rules and regs? And they remind me to go, look, we realize what you're going through is really painful and tough, but you guys are doing the right thing because we didn't do it in California. And we've seen, you know, huge drops in our aquifers, subsidence problems, subsidence problems. It's just ironic that they have a real appreciation for what we're trying to do.
Yeah. Yeah. And like I said, I think that's one of the main reasons that land prices are going, irrigated land prices are going up so high, is because we have some assurance that we're going to have that water 20, 30, 40 years from now, and there's some areas of the country that might not be the case.
I'm not a farmer, but as a urban dweller, I look around and I think, you know, the valley is unique. We are working between ourselves and our neighbors, and we're interested in seeing the valley continue, so we're interested in seeing the water sustainable. And I don't know if there are many places on the face of this planet that really are making as good decisions as we are here in the valley. It makes me proud as an urban person to watch farmers saying, that's my neighbor next door, and she and I, or he and I have to work together.
Mm-hmm. Yeah, exactly. There's going to be some fights and some arguments between people, as there always is. But I think when you get right down to it, people, especially water users here in the valley, understand that we need to do something, and they understand that people are trying to work in good faith to get that done.
Yeah.
Yeah. Mike?
No, you don't want to hear that. So, have we abandoned our law about our first in time, first in right, and shutting down wells, and we're not going to shut down wells, and have we abandoned our, maybe we should shut down the 1980 wells, 1970? Is that not even a consideration in the minds anymore?
It's not a consideration in the rules. There again, because we don't want to tell people how they can get to where they need to go. But I know some sub-districts have at least thought about that. That's a potential solution, shutting off some wells that are maybe junior to some other wells. I don't know if any of the sub-districts are going to actually go with that, but that has been discussed.
But see, you have abandoned there if it's the sub-district's responsibility to do that and not the state.
Well, so under the priority system, as long as the wells are replacing their depletions and they're not injuring a senior water right, then they can go ahead and pump, and that's kind of the deal. And so if they do have a good plan and it's been approved by the state engineer and approved by the judge that says that they won't injure any senior water rights, then we can let them go on that.
What you've outlined this evening is the old axiom that all politics are local.
Mm-hmm.
You've moved it all to here, so that everybody who's using has to work with everybody else who's using.
Yeah.
And so it's not that big guy up there in the state
Mm-hmm.
who's calling the shots
Right.
about everybody. So
Yeah.
I guess one way or another, everybody's gonna have to work together, right?
Yeah.
Well,
Yeah.
it's good to work together, but at the same time, you have to protect the priority system.
Mm-hmm. Right.
That's all there
Yeah.
is to it, and like you said about the wells, the older ones, the newer ones. Well, it should have been up to the state, we need to put them in the priority system. They
And-
do the surface right, there shouldn't be any difference.
Yeah, and that's definitely a possibility for sub-districts to look at that and do that. But kind of the bottom line is where the legislature says that we're only supposed to do the minimum necessary, and they don't want us to overstep that. Then that's, as long as the wells in a certain area are meeting their obligations, then we're saying that's good. Yes, ma'am.
I was recently, in September, I went to a special districts conference, and there was a lot of water law discussed at the time. And something that was really interesting, because a lot of folks come from the Front Range, and the perception of the lawyers and the people there are urban-based, not
Yeah.
agricultural-based. And they're doing everything they can to change water law for a more urban use. And as far as shallow reservoirs that comply with water allowable, it's really, they're doing everything legally that they can do to hang on to the water they have so that their urban, city residential areas are protected
Yeah.
from any kind of thing. So it's kind of, when you go into that perspective and you come out of this one, it's a little bit scary.
Yeah, yeah. Cities are always growing for the most part, and they're always looking for additional supplies of water.
They work hard for it.
Yeah, they sure do, and I think it's getting harder and harder for them over the years. You know, it used to be fairly simple. They'd go out on the Eastern Plains, for instance, and just dry up, you know, hundreds of miles of irrigated land and take that water, and that's definitely not the case nowadays. That's frowned upon, and so they're looking harder and harder for some viable sources of water.
And a lot of these is expensive.
Mm-hmm. Yeah. Yep. That's true. It's a big deal. We all need water. Mike?
I think we need to look at it more as not a urban versus agricultural thing, but it's more of a, like a communal versus a private property right thing. And I think that's where the arguments are, if the urban people, and they need water, they need water worse than the agriculture. I think the agricultural community could probably, in this country, I don't know about this community, but in this country could get by with a lot less ag water. And eventually that will go to the urban, because that's where it's needed, that's where the highest value is. But it's changing it from a private property right, as it was established 100 years ago, into more of a communal property right, and I think that's the danger.
Yeah, and that brings up something, a good thought too, is that you know, we have this kind of aversion, I think, to drying up ag land and moving it all to the cities. But on the other hand, that the water rights are owned by individual people, and we can't tell the individual people, no, you can't sell your water rights, and so they have a right under Colorado law to sell their water rights.
Which they tried to do there in the San Luis Valley after the EPA told the Denver Water Board they couldn't build two forks dams.
Mm-hmm.
The attorneys that they had carefully placed in Washington within the EPA and also within Colorado themselves told everybody, well, you can't, it's not feasible to move water from the San Luis Valley to Denver so that they can continue growing lawns. As soon as the EPA said no, all those attorneys came down to San Luis Valley and tried to buy off the water rights. So, I don't know if they were investors or...
Well, and
they should stay here.
yeah, and one of the things that, like AWDI did, I think their biggest problem was that they weren't water rights owners. They wanted to develop new sources of water and not buy up other people's waters. And there's just no new sources of water available here in the San Luis Valley.
Well, it's a finite resource.
Yeah, right. Yep.
All right, well, thanks a lot, Mayor. Good
Sure.
talking to you.
Yeah, thank you.